My name is Jack Turner, and I've learned something about threats. Most of them are empty, but some reveal exactly how far someone is willing to go. My ranch sits just outside Silver Creek Estates, far enough to be independent, close enough to be inconvenient. For them, for years, it didn't matter. We kept to ourselves, they kept their rules to separate systems, no conflict, until property values started rising. Because when money enters the picture, boundaries start to blur. The first letter came on a Monday morning. Plain envelope, no return name. Inside, a notice: outstanding HOA compliance review required. I read it once, then again, because something about it didn't make sense. I wasn't part of their HOA, never had been, and my land was recorded separately long before their development existed. So I set it aside, because sometimes ignoring something is the fastest way to see what it really is. The second notice came 2 days later, more aggressive. Failure to respond may result in lien action. That word stood out. Lien, because that's not a suggestion, that's a step toward control, and control is what this was really about. I drove down to the HOA office that afternoon. Glass building, clean signage, everything designed to look official. Karen Whitfield was inside, of course. She was beside for us, placing the letter on her desk. She didn't even look at it. You're out of compliance. With what? Community standards. I'm not part of your community. She leaned back slightly. You're within our expansion zone. I almost smiled. That's not how property law works. She didn't like that, because people like Karen don't respond to facts. They respond to resistance. You'll need to resolve this, she said. I don't. You will. That was the moment everything shifted, because this wasn't a misunderstanding anymore. It was an attempt, and attempts escalate the next week. The notices kept coming. Fines, warnings, threats, each one more aggressive than the last, each one more disconnected from reality. And then came the final one: failure to comply will result in foreclosure proceedings. I read that one twice, not because I was worried, but because now it was clear. They weren't just pushing, they were overreaching. And overreach creates opportunity. I didn't respond immediately. Instead, I made a change. Not dramatic, not dangerous, just clear. I reinforced the boundary, installed a proper security fence along the lower edge of the property. Steel posts, solid panels, clearly marked private property, no trespassing, visible from the road, impossible to ignore, and more importantly, legally compliant, because everything I do is backed by documentation. The reaction came fast. Karen showed up the next morning, angry, immediate. You can't put that up, she said. I stood by the gate. Yes, I can. This violates HOA visibility standards. I'm not in your HOA. This affects property values. I nodded, not my concern. She stepped closer. You're going to regret this. I met her eyes. No, I'm not. That's when she made the mistake, the one that ended everything. She escalated. Filed the claim, started the process. Tried to place a lien, tried to make it real. But here's the thing about legal processes. They don't run on confidence. They run on proof. And she didn't have it. What she did have was documentation. A lot of it, every notice, every fine, every claim, all recorded, all submitted. Because once something enters that system, it doesn't stay hidden, it gets reviewed. The hearing came faster than she expected, because cases like that get attention. She walked in confident at first, clipboard in hand. Same tone, same posture, same belief that she was in control. I walked in with a folder, thicker, heavier, because facts take space. The judge didn't waste time, reviewed the filings, read the claims, then looked at the property records, original deed, boundary survey, jurisdiction maps. All clear, all consistent. Then came the key question. Is this property part of the HOA? Karen answered quickly. Yes. I didn't say anything. I just slid the document forward. Stamped, recorded, verified. The judge read it, then looked up. No, it isn't. Silence. But not for long. Because once that was established, everything else started to fall apart. The fines, invalid. The notices, unenforceable. The lien attempt, improper. And the foreclosure claim, completely baseless. Karen tried to explain, tried to reframe, tried to minimize, but facts don't shrink. They expand, especially in a courtroom. The ruling was simple, clear, final. All HOA actions against my property dismissed. And more than that, damages awarded, because misuse of legal process has consequences. Significant ones by the time it was over. The total came out to one number, one she never expected to hear. $185,000. Not because of the fence, not because of the land, but because of what she tried to do and how far she pushed it. She didn't say anything after that, didn't argue, didn't protest, because there was nothing left to say. The HOA couldn't protect her, couldn't contain it, because this wasn't internal anymore. This was legal, documented, final. She stepped down within weeks. No announcement, no explanation, just gone. Same pattern, different mistake. As for the fence, it's still there, solid, quiet, exactly where it should be. Not to keep people out, but to make something clear. Boundaries exist for a reason, and every time I drive past it now, I remember something simple. Karen thought a threat would force control, but all she really did was push the situation into a place where control didn't matter anymore. Because once it reached the courtroom, the only thing that mattered was the truth. And the truth didn't belong to H.